in this SLSA video, I'm talking with Dr. Natalie Ohana from the University of Exeter School of Law. In 2023, Natalie was awarded the SLSA Best Article Prize for her article, "The Politics of the Production of Knowledge on Trauma, the Grenfell Tower Inquiry." The article was published in the Journal of Law and Society in 2021. Natalie is here today to speak about this article. Thank you and congratulations, Natalie.
Thank you. Thank you so much, Richard.
Well, to begin with then, I just wanted to ask if you could tell us a bit about the background to this project, and particularly, I suppose, how it complements or departs from what you've been working on previously, your prior research.
Yeah. So I started the work with Grenfell when I was a fellow. So when I was in my fellowship from the British Academy, a postdoctoral fellow, and the postdoctoral fellowship was on the relationship between law and trauma. But the way I framed it then, and the way I posed the question was, how do traumatic events, how are they understood and how are they represented by the legal system? And so when Grenfell happened, it was very clear to me that really that does sit exactly in my research question. And I just wanted to understand how the community experiences the inquiry. So that is when I shifted the project to Grenfell. But I think through the work with Grenfell, my research question itself changed. And maybe we can talk about it later because it's relating to the theory. But so that very much is continuing my research area. It's deepening it. And only with working with Grenfell, I could see also how it actually related to my work before the fellowship. So even to my PhD as well.
Oh, that's really fascinating, because I found that theoretical lens really interesting. So, I mean, why did you feel it just was particularly appropriate then for the Grenfell inquiry, and what was it able to reveal, this particular sort of theoretical lens?
Yeah, so it was through the work with Grenfell that I had to really think about the question, why is this lens effective, and in which way is it effective? What can we see through it that we couldn't see through other ways, I think, but this is particularly effective in seeing what I was trying to reach. And that is when it became clearer. So the understanding that what I'm really interested in is questions of power and how law participates within relationships of social power and oppression, and the understanding that through trauma we can see the way that law takes part in the kind of larger picture of powerful structures, structures of oppression. And the reason is that oppression serves as a habitat for traumatic events. So there is one type of traumatic events, and these are the types of trauma related to oppression. So, for example, thinking how racism can act as a habitat for traumatic events related to racism, or of course sexism or class related. So that understanding that oppression is needed as the habitat, and without that oppression, those traumatic events could not have occurred. So it's not really about only the perpetrator, it's about how society creates that those set of conditions that enable trauma to occur. So and I think that's a very clear link, and I think it's a link that's very clear to many people. So how oppression and trauma are intertwined. But then coming to it from a socio-legal perspective, it meant that, okay, so if we see that link very clearly, then it means that if we interrogate the legal responses to trauma, it is actually a way to understand how law participates in those bigger questions of power. And that is what Grenfell made very clear through the work with the community. And it really helped me to define, my area and where I want to take it, and what I can do with it, and what would be the next steps as well.
Oh, thank you. Well, in addition to the theoretical design of the project, your socio-legal methods also appear to be quite original. So could you tell us about these aspects of your methodology and why you decided to carry out the research in this way?
Yeah, so I think it relates as well, again, to the question of how do we conduct socio-legal research when our aim is to interrogate the law-power relationship. And I think then so language becomes very central. So the question of whether we can use language as our sole means of communication and understanding. So language as an instrument of society can be in and of itself an instrument very much related to power dynamics. And this is relating to work I did before. And there was one particular theory that really resonated with me, and this is the minor literature theory by Deleuze and Guattari, who kind of interrogated Kafka's work, so Franz Kafka's work, and basically said that he did something very different with language. He did write in German, but he wrote in German in a very different way. So he didn't write in German using the canon, using the current canonic literature in the German literature, but he actually broke that language and then used the kind of pieces to create something very different. But what was important in that theory is to say that through doing that, he was able to expose power, right? So in that sense, it's the minor literature, not minor as in secondary, but minor as in minority, right? So he had to change his way of expression to express that minority reality. And to do that still in the German language, so it means that he can communicate that with the oppressor as well and the larger audience. So it's just that principle that remained with me, that we need to break this sole means of communication to make the English language not our main way of understanding. And so how can we do that in research? And so that was my thinking around behind that, right? So what happens if we start with expression of ideas through art, which is not, art for the artists, it's just, expression through colors and through marks and maybe intensity of colors. But what happens if we first express our thoughts in art, through art, and only then we have a conversation about it, whether that can break those kind of the hegemony that the language creates. And of course, because working with Grenfell even more, so we had to break that kind of dominance of language, because most of the participants' English was not their first language. And I found it really effective in really being able to use that method to be able to, reach more people and for people to say more subtle meanings of what they were trying to say. And yes, I thought there was something in the method that kind of lent itself for kind of content on power to be shared. And I do think it's related to the art, but I'm still in the process of formulating how and why that's related.
Well, just moving on then to what you were able to find then, your findings. Could you tell us about what was being excluded then from the inquiry and how you saw it being excluded?
Yeah, so really so the whole work was 3 days of ongoing workshops with small groups of people. And I think it was very much, something like in the middle of the first day when the answer was very clear that for the community, the question has to be whether there was something related to discrimination that allowed this to happen. And discrimination, back then there was a lot of vagueness around what actually happened. It's related to how the inquiry constructed the narrative, how the lawyers had to be part of that narrative. So the participants kept, saying things like, were not treated the same. No, so there is one borough, that's the Royal Borough of Kensington and Chelsea, but the borough has people who are social housing residents, and then the majority of the residents are private accommodation residents. And there was a lot of the content came back to that same point of actually there is a whole difference in treatment. So the same borough acting differently towards two groups of people. And that was, clear as day, it was very, very clear. And then it was also clear that the inquiry is not including that question, even though, coming as a socio-legal scholar, but also as a lawyer. So I've been practicing law. I'm a lawyer in Jerusalem. We know that discrimination is a legal question. It's not a complex, political question. Discrimination is a legal concept. It is possible to research whether, to conduct comparison and to see whether two groups are treated differently, and that the inquiry is refusing to do so. So that was the first main understanding from the workshops, that there is a crucial central question that is not being looked at by the inquiry. And the ensuing perception of the community that the inquiry, by not doing that, is not really asking the most important question. And it kind of lost them in terms of their sense of trust in the inquiry. And so the whole work then became, okay, so how can we understand the fact that the community is all represented by lawyers? So the government decided to fund legal aids for all participants, so that would make anyone think that they can participate in a meaningful way. They also received that status, core participant. So I think for most people in the public following the inquiry, they would think that the community is very much a central part of the inquiry and able to influence it. So the question, it was, how come that is the image and yet the reality is so different? The reality is that actually the community's most important question is not really there. So that was the remaining of the 3 days, to understand what are those practices, those more kind of micro practices that are less clear to an outsider and to a kind of someone who's observing it all from the outside. And that's when the findings, we reach those conclusions that it's happening through, obviously, first of all, refusing to include that question in the terms of reference, which is plainly, a direct exclusion of knowledge. And then the second way was by marginalizing the participants from the inquiry. So it's true that they had lawyers who represented them, but the article looked into how actually that lawyer-client relationship in this case led to weakening their participation, and not the other way around. The venue of the inquiry became clear that played a role in, again, marginalizing and weakening that participation. I think the third one was how this whole way of relating to the community led to that break of trust, as I said before, but then it meant that the community started to withdraw from the inquiry. So they started to be, less keen on reading everything and participating in every single meeting. And I think that is actually a mechanism, again, of exclusion, because, again, the community were the people who held that knowledge. They knew, they had the evidence as well. They knew how to ask the questions. They knew where to look for the answers. So the inquiry did all those things consciously or unconsciously. It's not really about whether it's conscious or not, but in practice, there were many ways by which the community then remained not genuinely participating in the process. So we were left with an inquiry that really didn't ask what the community thought was the main question that needed to be asked.
Well, that leads me into a sort of question about, well, what were the consequences then of that for the community, and I suppose for how the general public see the inquiry now?
Yeah, so I think there is, okay, so it needs to be disseminated more, and more work needs to be conducted for the legacy of the inquiry to change. So we need the public to be much more aware of what actually is going on, and of the fact that we all need, it's not only the community who needs, we all need an answer to the question whether discrimination played a role in this. Because if it did play a role, then it's not only about Grenfell specifically, it's about many other communities in the country. But what happened was that the inquiry, created the narrative right through its terms of reference, and that started a 6-year process, an ongoing process with something like 200 lawyers representing the community, with many different questions that were asked. And within that dominant narrative, it was very difficult to start a very strong campaign to make the community really fight for the question of discrimination, right? It was obviously, years of trauma and grief, and it's still very much, we're still early days in terms of trauma. It's only 6 years into what happened. So for many people, the trauma is very raw still. So to be able to completely contradict or to really question or contest the narrative of the inquiry in those conditions of, on the one hand, trauma, but on the other hand, that image of, the inquiry is very thorough and very busy with asking many other questions. I don't think the conditions were ripe for the community to start this campaign. But so the plan is to continue the work. So in September, I'm going to do follow-up workshops, again with the community. But this time the workshops, the way they will follow up on the previous ones, will be really to center on the question of institutional discrimination, and to see what it means for people, whether they relate to that, and in what way, and do they have examples. And it might be that now, so the stage we're at currently is that the inquiry completed its evidence gathering stage. So it's now writing its final report. So it means that the community is just waiting for the report. So the lawyers are not involved anymore. The lawyers' clients' relationships have pretty much ended, and the community is now much freer to think about the next steps that they want to take. And I think a very positive outcome of the work from the previous workshops is that I feel I got to know the community much more, and I feel that a trust has been built, especially through the article and through the messages and the kind of points that were emphasized in the article. So now when I came to organize another workshop, I felt that people were much more very open and willing, whereas before that, I was outsider to the community, and I had to really build my way in to explain why these workshops are important. And now with the workshops that we're going to run in September, it was much more straightforward, and people came and said, yeah, definitely, we need this time. We need to talk to one another and to understand where we want to take it. But I think, this is the work that needs to be done in relation to the inquiry. The question of institutional discrimination, and maybe to focus and to zoom into the RBKC, so the Royal Borough of Kensington and Chelsea, as the most important party or body that needs to be looked at.
Thanks. I was going to conclude to ask really what you're currently working on, but you've sort of hinted at it there. Is there anything you'd add to that? So you're still working on the ideas and themes in the article?
Yeah. So I think, I'm still working on the inquiry. So at the moment I'm writing an article, and I'm thinking about the concept of denial. So what is institutional discrimination denial? And how can we explain it, right? So how come, even though this is the elephant in the room that is very clear to, I think so many people it's very clear to them that discrimination was central, and yet it remains only an elephant in the room. It's not spoken about. So how can we understand this denial? So I'm first showing expressions of denial in the inquiry, but then I'm looking into psychoanalysis, so theory, so Freud's theory, to think about the undercurrents of denial in the context of Grenfell. But I'm also writing another article with David Barrett from Exeter, and his expertise is discrimination. So we're thinking about what would be the legal framework of actually adjudicating institutional discrimination in the context of Grenfell, whether the Human Rights Act is a relevant provision for this purpose. And I'm also hoping, so I'm applying for a grant to create a critical trauma studies network, which will be an interdisciplinary network of people who think about trauma to think about power. So it won't be only from a legal perspective, but yeah, to bring together artists as well, who kind of make that link between trauma and power. And I think many people do that. So it will be really interesting to meet more people and to start to work together and to see what the network can kind of create.
Well, that does sound interesting. Thank you so much, Natalie. Congratulations again on winning the SLSA Article Prize. If anyone watching has not already done so, I encourage you to read Natalie's excellent article in the Journal of Law and Society. Thanks again, Natalie.
Thank you so much.